You told two distinct stories, but neither one of them suggests that this child did anything wrong.
Welcome to MsMojo, and today we're counting down our picks for the litigants who tested Judge Judy's patience with their weak and sometimes offensively bad excuses.
Okay, all I'd like to see is photographs of your car.
All right, you'll see scrape marks on it.
Just show me the pictures.
Number 10, I don't remember.
Do you remember that? No. You don't remember going upstairs to get him and saying, I've locked the kids in the car?
No. Ivory Clark is not the first litigant to suffer sudden and convenient memory problems in Judge Judy's courtroom. However, it seems particularly egregious here. The plaintiff, her mother's boyfriend, had to smash his own car window to get Clark's infant out of the hot vehicle, avoiding what could have been a tragic accident. He sues her for the cost of replacing the window and for the removal of trash she left when she moved out of his house.
Well, you told him you would pay for the window.
I probably did, but I don't remember.
Okay, now let's get to the dumpster.
Clark blames her mother for the whole event. She says that she can't remember promising to pay the plaintiff back, nor does she remember the day she moved out of his house. Given the circumstances, repayment is the very least she could do.
So as Ivory came up to tell me that the child was locked in the car, first response out of my mouth was, you need to call a locksmith.
Number 9, freedom of speech.
And I quote, "You want me to pick this up, you blankety blank blank blank," unquote. And things went quickly south after that.
A dispute about tree trimmings on the wrong side of the property boundary turns into a feud of epic proportions. Plaintiff Stephen Hesley was irritated that his next-door neighbour, Sheila Blavovsky, left trimmings in his yard. Things escalated enough that police reports were filed. The judge isn't impressed with either litigant. However, Blavovsky admits that she turned up the heat by protesting in front of his house, shouting expletives into a bullhorn and disturbing the peace of the neighbourhood. Blavovsky insists she's just exercising her First Amendment rights.
Brushes off the trim off of my side of the fence. In doing that, his side of the fence fell.
Judge Scheindlin disagrees. She calls it disorderly conduct.
The result was his side fell off because I cut off my side.
Oh, I see. Now you're not talking about the fence, you're talking about the trimmings.
Yes.
Ah.
Number 8, I thought she had full coverage.
Your sister says she really had your permission because she used to borrow the car all the time. You left the back door open, she grabbed the keys.
The Dettenheim sisters are in court over a matter of car damage. Carol Dettenheim insists that she could borrow her sister Eve's car without asking because she had borrowed it in the past without issue. But then she hit a deer. Eve Dettenheim didn't appreciate Carol's offer of deer stew. She just wants her to pay. The judge is surprisingly patient with the defendant, even though many of her answers demonstrate complete obliviousness.
Damaged the car, and her defense is you should have had better insurance. Is that your defense?
I thought she had full coverage.
She thought Eve had full coverage car insurance. It doesn't occur to her to pay for the damage, though. The judge suggests she get a job and pay her sister what she's owed.
No, I put pine straw over it and took the antler and went and got it later.
Number 7, I don't keep secrets from my children.
And you did that because I don't believe in keeping secrets from my kids.
Yes.
You're a moron.
Judge Scheindlin's years in the family court system came back with a vengeance in this case. She is not impressed with litigant Kathleen Kreftmeyer's parenting. She admits to telling her 6-year-old daughter that the plaintiff might not be her father. There was no decent or appropriate reason to tell her this. But Kreftmeyer explains that she doesn't keep secrets from her kids. This fills the judge with rage.
You say that 5 years ago, when your daughter was 6 years old, you had a talk with her. And you told her that there was a chance that he wasn't her father.
She can't believe a mother would tell a child that young that her father might not be their biological father, especially since she has no conclusive proof. It's a gigantic lapse in judgment.
All I know is, madam, you are one of the most marginal people that I've come across in a long time, and you haven't even said 2 words.
Number 6, the landlord didn't want the rent.
When she found out about the
You
housing...
weren't confused about not paying rent.
She did it out of retaliation, though, because we called the housing services on her.
Who cares?
When the landlord gave them the legal 30-day notice to vacate her apartment, defendants Patrick Valdivia-Menzel and Rachel Bachakis heard something very different. They tell Judge Judy with a straight face that they took this as her not wanting rent money anymore, but they would absolutely be happy to stay in the place rent-free. For months, that's exactly what they did.
But she told us that she didn't want any more money, though. She said that She didn't want to go through an eviction.
Go tell him about
She didn't want to go through an eviction.
The audacity of that defense is unbelievable. It makes their argument about harassment and filing an order of protection against the landlord all the more ridiculous. Apparently, being asked for rent is harassment. If that's true, we will have a case.
What you do is you don't call housing and say, I want to know what my rights are. And
Yeah, 'cause I want to know if she could throw my stuff in the
You're
street.
not talking over me, and then stop paying rent. That's what you don't do unless you're a squatter.
Number 5, 2 entirely different stories.
Like, she had the leash on her hand while she was holding on to the strap.
I'm sorry, Your Honor, that is false.
As dog owners in these cases usually do, the defendants here argue their dog is docile. The bites the plaintiff's son sustained indicate otherwise. Lourdes Rodriguez calls the child a liar for the first few minutes. She tells the judge that the plaintiff and his son are making up an elaborate story because the boy actually purposefully scared her dog, so the bite was warranted.
And we kept walking, and then my dog started barking as we had already walked off.
Her version of events don't square with her answer to the lawsuit. The judge is angry because not only can Rodriguez not keep her facts straight, but neither one absolves her of guilt in the dog's actions.
She's given 2 different stories, but not one reason.
It's the same story, just one story is more elaborate than the other.
Number 4, I don't care what you believe.
And you abused the system, and you abused him. Now, if you felt threatened, which I think you did not.
2 co-workers arguing over a woman end up in a legal case when defendant Joshua Sumrow had a feeling the plaintiff was going to harass him at their shared workplace. She susses out very quickly that Sumrow was unfairly using an emergency protective order to try to get his co-worker fired. He insists he believed the plaintiff might do something.
That Mr. Sylvester said or did to you that inspired you to file for a protective order against him, excluding him from your workplace.
As angry as she gets, it's rare to hear her curse in the courtroom. But if there's one thing she hates more than people who don't respect her court, it's people who abuse the legal system.
Maybe your sister cares how you feel. The law doesn't give a rat's ass how you feel.
Number 3, take care of this baby.
So I have proper documentation. Your stepfather, according to you, came in and said, what are you trying to do?
Valencia Carroll arrived at her mother and stepfather's home with a strange request. She wanted to leave her friend's young child with them to take care of indefinitely. The judge already smells a rat. This all seems a little unsavory. Allegedly, Carroll went on a tirade that ended with a broken TV and her stepfather's car being vandalized. Carroll's excuse is that it wasn't her fault. She says her stepfather pushed her into the TV and his own car.
Well, Larry pushes me into the TV. My elbow then hits the TV.
What?
My mom grabs him.
Okay, now let's stop right there.
Nothing she says makes any sense. She wants us to believe that none of this damage was a result of her rage, but her decisions up to this point don't give Shindlin much faith in her judgment.
Yes.
After she broke the TV.
Yeah. When I come downstairs, she already has the windshield wiper, and she's banging out all over my car. She's running around in circles, hitting different parts of my car.
Number 2, maybe the baby was having a bad day.
Within 24 hours, the baby was in surgery for a broken leg. You think that that's coincidental?
Running a daycare out of your home is already risky, as defendant Heather Shearer found out. When the plaintiffs arrived to pick up their children, their infant was injured. Shearer blames their 9-year-old for roughhousing with his younger brother. Unfortunately, that defense makes things even worse for her. The brother was also under her care at the time. Shearer still won't accept responsibility. The baby, she says, might have just been having a bad day.
So I assume from this answer that, according to you, it's the 9-year-old's fault.
I don't know that it happened in my care.
The judge had some stern words for her and her home state's licensing practices. If you're in this lackadaisical, it's probably best to leave childcare to the professionals.
How could any state allow you to take care of children? You see a 9-year-old playing roughly with a 4-month-old infant who you have already told to take out of a swing because the baby was crying. That's your job. You leave the sink or you leave the television.
Before we continue, be sure to subscribe to our channel and ring the bell to get notified about our latest videos. You have the option to be notified for occasional videos or all of them. If you're on your phone, make sure you go into your settings and switch on notifications.
Number 1, no earpiece, ma'am.
My wallet.
What was in your wallet?
It was $50.
Okay.
I had to replace all my IDs. I had gift cards in there.
Some legends are born and some are made through sheer force of stupidity. Accused of stealing plaintiff Ginny Paradise's book bag and all its contents, Stephen and Samuel McKay deny this. They were just there when someone else stole it. It doesn't make them look good. Once Paradise starts listing out what was in the bag, one of them slips up and denies that one of the items was in the bag that they just said they didn't take. Whether or not they were the thieves or just the lookouts, their explanations don't wash with the judge. She takes pleasure in ruling against them, and a viral clip was born.
There was no earpiece in her mouth.
I love it. Judging for the plaintiff for the amount of $500. That's what I think it's worth, madam.
Which of these defendants had you yelling at the screen? Tell us in the comments.
What did you need 20 bucks for?
For my personal need.
No, tell me what you need 20 bucks for.
To buy some snacks or anything.
You needed
like
snacks?
That. Yeah.
Do you agree with our picks? Check out this other recent clip from MsMojo and be sure to subscribe and ring the bell to be notified about our latest videos.